Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida, and I'm going to talk today about defending sale of a business non-compete cases. There will be an entirely separate discussion for prosecuting sale of a business non-competes. Today's discussion focuses solely on defense. I'm going to break this discussion up into two parts. First, I'm going to give you an overview of the sale of a business non-compete landscape. And second, I'm going to lay out certain specific defenses. So without further ado, let's get into the mix. Number one, the general landscape. Sale of a business non-compete agreements are generally enforceable, full stop. You have to consider this in comparison to employment non-compete agreements, which are routinely subject to challenge, which are subject to a litany of defenses, and in many instances can ultimately be proven to be unnecessary and unenforceable. So employment non-compete agreements are readily subject to attack. Sale of a business non-compete agreements, much less so. It's important to understand the underlying policy framework or the underlying logic of why the landscape works this way. So I'm going to drill down into it for a minute. Non-compete agreements are generally used to protect a legitimate business interest, but ultimately to prevent unfair competition. A non-compete agreement is supposed to protect the legitimate business interest in an effort to prevent unfair competition. So apply that framework to the employment context and then apply it to the sale of a business context. In the employment context, does Joe Smith leaving one company to go work for a competitor necessarily entail unfair competition? Not necessarily. There are a lot of defenses to that argument. But now consider it in the sale of a business context. You have a business, let's call it Sunrise Technologies. Sunrise Technologies is acquired by Atlantic Technologies. Sunrise agrees to a non-compete. Sunrise and its principals, they agree to stay out of the market for 5 years. Is that restraint of trade, is that non-compete provision necessary to prevent unfair competition? Yes, it is. Why? Well, because Atlantic is paying several $1 million to acquire Sunrise Technologies. And as part of that transaction, as part of paying that money for that business, Atlantic is buying the right to take over the business, to take over those customer relationships, to take over the brand, to establish itself and to solidify itself as the new Sunrise. It would be textbook unfair competition for Sunrise to sell to Atlantic and then turn around 3 or 6 months later and get right back into the business, go after all of its old customers, use the company's confidential information, etc. That would be unfair competition. Let's go back. The example with John Smith. John Smith going to work for a competitor, that is a much less compelling case of unfair competition than we have in the sale of a business context. So, as a rule, sale of a business non-compete agreements will generally be enforceable, provided they are done correctly. Here's where we get into part two, which is specific defenses. Let me preface this by saying the defenses to a sale of a business non-compete agreement are incredibly limited. I'm going to give you a handful that I have seen in the course of my practice and that I believe can be very powerful defenses. Let's start with number one. I will call this the technical defense. Here's how the technical defense works. Let's go back to the hypothetical we used a moment ago. Sunrise Technologies sells itself to Atlantic Technologies. The non-compete says seller agrees that it will not compete with buyer for a period of 5 years anywhere in the United States. The non-compete uses the term seller. The agreement defines seller only as Sunrise Technologies. What's the problem there? Well, that's a terribly written asset purchase agreement. Because anytime you're selling a business and there's going to be a non-compete provision, it has to be clear from the text of the agreement that the non-compete applies not only to the seller, not only to Sunrise Technologies, but also to the owners of Sunrise Technologies, to the shareholders, principals, etc. Because otherwise, the owners and the shareholders of the company can simply close up shop with Sunrise, where they've sold all of Sunrise's assets, intellectual property, its name, etc., but there's still a corporate form, there's a corporate fiction that still exists. They can simply shut that down, and they could start, Miami Technologies, and they could go right back into the same business and start doing the same exact thing in the same territory. Why? Because of the technical defense. There's a presumption in non-compete law, it's built into the statute and it's borne out by the case law, that a non-compete provision will be interpreted to provide protection to whatever legitimate business interest exists. And this is basically an attack on the standard contract principle that a contract is interpreted against the drafter. So instead of the non-compete and the contract being interpreted against the drafter, the statute and the case law creates a presumption that no, it will be interpreted to provide protection to legitimate business interests. There's a huge difference, however, between this premise and rewriting the plain meaning of a contract. Let me explain. You can give effect to the non-compete to protect legitimate business interests, but you can't rewrite the deal. If the parties to the asset purchase agreement from the hypothetical, if they simply agreed that the seller, defined as Sunrise, won't compete against the buyer Atlantic for the next 5 years, and that's what the contract says, and the contract was not written to cover the seller's owners, its principals, its shareholders, etc., then that's what the contract says. And there's actually very good case law out there saying that in spite of this presumption of enforcement to protect a legitimate business interest or interpretation to protect a legitimate business interest, there is case law saying that even in the non-compete context, words have to be given their plain meaning. So if you have a contract that only says the seller can't compete and the seller is only defined as the corporate entity, not the individuals, then you potentially have a get out of jail free card in which you could start another competing venture and not be bound by those restrictive covenants. That's one. I refer to that as the technical defense. Number two, there is a defense based on prior breach. This will depend on exactly how the agreement is written, but as a matter of pure logic, there must be a prior breach defense built in to any sale of a business non-compete. I'll explain. Someone is purchasing the business. Let's go back to the hypothetical. Atlantic is going to pay $20 million for Sunrise Technologies. Atlantic pays $10 million up front. They have a note for the remaining $10 million, and they're supposed to pay it off $1 million due every quarter. So Sunrise sells, Atlantic takes over, Sunrise is sitting back on the sidelines, Atlantic makes the first couple payments, and then they just stop making payments for no apparent reason. They decide, we're not happy with the business, we're not happy with what we acquired, we think we paid too much for it, we still owe $5 million on this note, but we're not going to make payments anymore. We feel like you tricked us into this asset purchase agreement, and you got a sweetheart deal. So at this point, Sunrise says, well, Atlantic is violating the terms of the APA. They're not paying us the $20 million they owe us. They're not making good on their quarterly $1 million payments. Screw this. We're going to get back into the business. At that point, Sunrise gets back into the business. Atlantic promptly sues and seeks a preliminary injunction, arguing that they are violating the non-compete provision. Does Sunrise have a defense? Absolutely. Sunrise should have a viable defense there based on the doctrine of prior breach. That is, in a nutshell, what your prior breach defense looks like. Finally, another very potent and very common defense in the sale of a business non-compete context, the geographic scope defense. Okay? As a rule, the buyer of the business has a right to keep the seller out of the relevant market for a reasonable period of time. And that encompasses the relevant geographic market. If Sunrise only did business in the state of Florida, they get acquired by Atlantic, and the non-compete is nationwide for a period of 5 years, that is going to be geographically overbroad. The rule of thumb is that the geographic scope needs to accurately reflect the geographic territory in which the company did business. So in that third instance, Sunrise could potentially say, okay, Atlantic bought us and they get Florida, but there's nothing to prevent us from going back into business in a different geographic location, provided it's not going to actually compete with Atlantic. So to recap, as a rule of thumb, sale of a business non-compete agreements are generally highly enforceable. They are subject to limited defenses. Certain of the best defenses that I have seen are the technical defense. Sorry, the company was subject to the non-compete, not the owners, not the shareholders. 2, the defense of prior breach. You owed us money on the transaction as part of the APA. You breached it. We're discharged from our non-compete obligations. 3, the geographic defense. The geographic scope is overbroad. We sold for Florida. We're allowed to get back into the business somewhere else because there's no actual competition. Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida. I love this stuff. If you have a question or a concern about a non-compete issue, please feel free to call my office. I'd be happy to talk. Thanks for watching and have a good day.